Hi, welcome to Delfino Co. Business Brief. And today we're going to have Francisco Mundaca, founding partner of Mundaca Law Firm. We're going to discuss about why informal contracts cost contractors real money. We have him with us today. Welcome, Francisco. How are you doing?
I'm doing well. How are you, Giovanni?
Good. Thank you for you joining us today, and we're going to discuss about this important matter, which is why informal contracts cost contractors real money. As we know, many small businesses when they start, conducting business, they start running and getting their first contracts. Sometimes they don't have a well stipulated contract because they're trying to get not just the job done, but trying to close more contracts easier. So they try to be flexible. They try to do, I'll say, be as fast as possible to be able to close. But what does this really mean at the long term?
Yeah, you hit on a lot of things in that introduction, and so starting as to why it's important is understandably so. Contractors are looking to close. Of course, they're bidding out projects, and it's about turnaround time because you can imagine that the market is saturated and the potential uh, uh, contractual party that's part of the deal is fielding more than one bid, as they should. And so, the goal is to get your bid and estimate in front, but then there are tight windows based on the start of the project. So what does that lead to? Well, oftentimes what we're seeing is that our clients are not engaging in a written contract. At times, what we're seeing is that they're verbal, which has huge effects because of the fact that the law has different timelines as to the enforceability of the contract. And so while a verbal agreement may be seen as a contract, it may not have as much time to bring in a potential claim if there is a dispute as to the project in hand. That sort of spiders out into many other things: scope, price, adjustments that are made. Frequently there are amendments to construction contracts that have to be all looped back into the original deal. And so what we're seeing then from that point of view is that there is a disorganized pattern. There is a failure to have a core based agreement, which then has huge effects because frequently in construction, parties are withholding funds. They're not completing projects. Subcontractor to general contractor has its own issues, payment. And so there, what we want to do intentionally is to create a foundation for a business to be able to move freely because they have a ready-made contract which they can edit as opposed to have to draft from scratch. They're adding exhibits as to scope of the agreement and not the language itself. And that's going to be benefit the quick turnaround times because frequently time is of the essence in many of these projects.
Right. As you know, I meet with small business owners all the time, whether it's for advisory or education through trainings. And what I they tell me a lot of times is um, sometimes they get a contract, they try to close the deal. They're trying to be as flexible as possible. They don't have it. They don't have a written contract or a really well stipulated contract, and they're an attorney. And then what they didn't expect happens, right? So they maybe the other party, was already planning to make changes in the deal along the way, or they start adding up work, and they are not willing to pay until that additional work is done. And then ultimately, when they get at the end of the job, sometimes they don't even get paid at all. So, how can we, or what do you say to small business owners who are in these cases, debating whether it's really that important to get those contracts done?
Yeah, that's a really interesting topic because I understand that attorneys' fees that they're not small. Well, let's be honest, right? But as a business, I think an important caveat is that attorneys' fees are deductible as a full business expense. And so while I understand that the initial outlay would be heavy, the cost that it would save you, preventing you from leading to litigation, I mean, it pales in comparison. For perspective, drafting initial documents can range anywhere between 3 and 10,000, depending on how verbose and how many things we're going to cover. I've seen businesses that are operating and often running without operating agreements, and there's more than one member, and they're entering into sales contracts, but their contracts were written by ChatGPT. I mean, it's really it's a little bit scary, but I think the goal is to just educate and allow business owners to slowly realize what it is they want to prioritize and why it's beneficial for them to handle that at the outset as opposed to midstream.
Right. I also find that in many cases it's a change of mindset, right? It's a change of mindset where you you have to think of what if, right? Or just to protect yourself and add value to what you do, right? Because also having that contract written also adds value to who you are as a business and what you do. And I don't know how do you ever encounter that like those cases? What do you tell small businesses when you talk about the importance of the contract in this case, for example?
Well, one of the things that immediately came to mind is perception. If you're presenting in a project and you're imagining that you're not the only bid, but your contracts are sound and they're well drafted, I think the other party is naturally going to take you more seriously because they're like, well, they've done their homework, they're protecting themselves, they're covering all the important bases, and it's going to make the transaction easier. I think what we see at times is that, oh, I'm not going to enter into a contract because I don't want to be difficult, or I don't want to lose the bid. I don't want to create issues with this contractor that I've done 10 other projects with. But it takes this one project. And I can't tell you I'd say honestly, in the past 90 days, how many contractors are coming to me. Okay, I've 3 outstanding contracts. In total, I'm owed $800,000. I've paid my employees so that I could make sure that the work is done, but they're not paying me. That's a problem, and that's a world you can't live in because that's not sustainable over the long term.
Right. Yeah, I have come across a case, for example, where this contractor was going over a similar situation where they already had projects going on with this specific company, and then they didn't know how to approach things to change the situation and start having an actual written contract with the stipulated. And then I asked them, so then when is going to be the right moment if it's not now, right?
That's right.
So it's what do you think? Sometimes people don't take in consideration in that sense, like because if you keep going and keep going in the same situation, when does that change? If you don't take action now, correct?
Absolutely. And you're right. And to your point earlier, I mean, it is a mindset shift. I think most people are inherently avoidant of confrontation. That's why there are a lot of attorneys out there, but it's not the profession for everyone. And so I think in this case, the contract is what plainly states what can be done within the bounds of that agreement. Now, there's always gray area. But one of the things that I've been advising contractors to do is that it's important to remember that breach of contract. So there's something that occurred during the project where a party didn't perform, or that could be whether they finished the job or they finished the phase, or whether there was payment. There's various ways that a party can fail to perform. But breach of contract does not permit the recovery of attorney's fees. And that's huge because oftentimes you may have, every project may not be a multi-million-dollar project. Some may be $30,000, 20, right. 15. And if you don't have a clause that allows the prevailing party to recuperate attorney's fees, you might be reluctant to bring the claim because you're saying, I'm going to have to pay my attorney more money than what I'm owed. But that shouldn't be the case because obviously whether it's a bathroom for $10,000 to $30,000, it's still part of your bottom line, and that still needs to be collected if it was done well.
That's a great point. So I want you to repeat that one more time for those who maybe didn't get it the first time. So it's why it's important to have that clause in the contract will allow you to not only protect you, right, in the case of a litigation, but it will cover the expense of the litigation. If you can just say one more time for our listeners.
Of course. So the idea is that breach of contract does not allow for the recovery of attorney's fees. So what we like to include is a prevailing party clause. So essentially, if you were to win on the merits of your case, you would also be able to recover the attorney's fees that you expended in moving towards that case. Now, I'm going to couch that with saying you have to win and you have to be in the right. You can't fail to perform and then expect to get your attorney's fees unless you win at the end. And of course, if you were clearly wrong, then your attorney should advise you of that, so that way it can be resolved before you litigate. But if you do win, your attorney's fees should be fully recoverable if that language is found in the contractual agreement.
Great. Thank you so much, Francisco, for allowing these few minutes. Is there anything else you would like to add to those listening today?
Just generally that, I know it's a heavy lift to involve attorneys earlier on, but it's always best to at least speak to someone to generally understand what you need to do. And I think it's also realistic to build it out in phases. Just set real benchmarks, keep to them, and it'll help your business sustain health over the long haul.
Great. Thank you so much, Francisco.
Thank you, Giovanni. Have a great day.
Until next time. That was Francisco Mundaca, the founding partner of Mundaca Law. Well, we'll be back with more information for all our small business owners and managers across the Maryland, D.C., Virginia, as well as Texas and New York listening to